Welcome to the Supreme Court and Federalism. We're going to examine two theories of federalism jurisprudence from the perspective of the Supreme Court, and that is the judicial safeguards theory versus procedural safeguards. In a nutshell, what that means is that some justices believe that the federal judiciary must step in and preserve the rights of states and state sovereignty in order for the system of federalism to be able to exist and the unitary system not be formed by the federal government being too strong. On the other hand, some judges say, given the fluid nature of American federalism, it's much too difficult for the courts to be able to decide what issues are purely federal, what issues are purely states. And as a consequence, we really needed to leave it up to the political system as it was designed and the institutions as they were designed to preserve the rights of states. So there are obviously many more court cases than what we're going to examine here. But for today's section on this Supreme Court and Federalism, we'll take a look at the National League of Cities case in 1976, and then Garcia versus San Antonio Metropolitan Transit Authority in 1985. That's really where the essence of this discussion will come in. There are some important, the majority in that case focused on procedural safeguards, and then there are two dissenting opinions in the Garcia decision that focus on judicial safeguards. So after an introduction to these two concepts, we'll examine how that worked its way through the case in Garcia. All right, so let's start with the concept of what constitutes the judicial safeguards. And basically, in this kind of concept of how federalism should be preserved, the concept is that the federal and state governments are sovereign and equal, right? And on the overall framework of government that was designed by the framers to be able to preserve liberty, that there needs to be a differentiation between the federal and the state governments in order to be able to protect our individual liberties, that we should have recourse to numerous types of governments. And basically, they make the argument that, if you take a look at the way that the federal constitution is structured, there are some enumerated powers, generally those things that we look to in Article 1, Section 8, and then under the 10th Amendment, the rest is reserved to the states. But in reality, what we've seen over the course of American history is that this concept of what should be federal and what should be state is oftentimes in tension. And that means that there needs to be some sort of arbitrator that can step in and draw clear lines of constitutional boundaries between what a state government operation is and what a federal government operation is. And as we'll see when we take a look at the procedural safeguards, this means that judicial safeguards means that they don't believe the political process can be relied on, essentially because Congress and the president will, if given the opportunity, take power for themselves at the expense of the states. Therefore, it takes, judicial review by the federal judiciary in order to be able to preserve the rights of states, and they're worth preserving because of the idea of a balance of power between the two governments. The second idea here that they reject the notion of procedural safeguards is that they believe that there's a difference between the individual state interests, i.e., if you elect a member of the U.S. Senate, they represent their state. They do what's necessary in order to be able to get reelected. There's a difference between those individual state interests that get people elected and the collective interests of all states. So, the system may work well with helping states to get money, but no one is going to try to preserve the power of the states if they were a federal official. That there is this natural inclination towards centralization of power, and if there is not judicial review, we will end up having a more centralized or unitary system. So, for the most part, this judicial safeguard says we can't just rely on the procedural safeguards, that, we can't just rely on the policy preferences of members of the federal government because that means nobody would preserve the rights of states. And within the context of all these institutions that we'll talk about in a couple of minutes when we talk about the procedural safeguards, they don't create in the minds of people who believe in judicial safeguards any privileged position of state governments. There is no constituency that's elected or appointed at the federal level that is focused on representing what we would call spatial interests or the interest of the states as states, right? So, federal officials get elected and they're interested in what's good for them and their reelection capacities. And when they aren't necessarily concerned with preserving the power of the states vis-a-vis the federal government. Federal bureaucrats and bureaucracies, when they come up with policies, aren't really interested about preserving the rights of the states and the state sovereignty. Rather, they're interested in accomplishing their policy goals. So the short of this judicial safeguard theory is that we can't count on the political process to preserve state sovereignty. We need a backstop, and that backstop needs to be the federal court system. Now, let's take a look at procedural safeguards. They say federalism is very vibrant in the United States, and we've moved through many periods of federalism. As we've gone through American history, there's been give and take over the course, but the trend has been towards centralization. And so federalism is very vibrant. And basically, the courts shouldn't be the ones that are refereeing national state conflicts, because who are these unelected people that should be able to decide who has power and who doesn't have power? That really should be left up to the elected officials at the federal level. And the best exposition of this is Justice Blackmun, who we will hear more of in a couple of minutes in the Garcia decision, who basically argued that state sovereign interests are more properly protected by procedural state safeguards inherent in the structure of the federal government than by judicially created limitations on federal power. So what exactly would those kind of procedural safeguards be? Well, he says there are a couple of them here. And basically, the first is the electoral congruence of public officials will mean that they take the state and local interests into account. You are not going to get reelected if you don't represent the people that you have elected you. Therefore, I will look out for the interest of my state at the federal level when I'm a member of Congress or the member of the U.S. Senate. Okay. Now, we just heard that the judicial safeguards doesn't believe that that's necessarily the case, that they represent policy interests of the state, but not necessarily the interests of states as states. Political parties. The idea here is that political parties are generally organized at the lowest levels of government. Oftentimes, the people on the ground doing a lot of campaigns are at the local level and the state level, and they will keep their politicians in line to ensure that the interests of state and local governments are represented within the federal system. Now, there are a couple of big institutions at the federal level that Blackmun and other people who believe in procedural safeguards would say are instrumental in preserving the rights of states. So originally, the United States Senate was selected by members of the state legislature. And then with the 17th Amendment passed in the early 1900s, we saw that transfer over to individuals. But nonetheless, they're representatives of entire states. So in the procedural safeguards kind of theory, basically senators are representing states, therefore state interests will be heard at the federal level. And if something's not good for state sovereignty, then it will not be passed. The other thing is the Electoral College. If we examine the Electoral College, we understand that this is a state-based institution based on the size of states. In most states, 48 out of the 50, it's a winner-take-all system. So the states really speak to the Electoral College, the chosenness of our U.S. president. Therefore, the Electoral College in and of itself is a state-based institution, and the interests of states are tied up in that. So that would be important as well. And one thing I don't have on this slide, but it's also important, is that if you take a look at the way that the U.S. Constitution is amended, what we see is that it takes 2/3 of both houses of Congress, but then 3/4 of the states have to ratify a constitutional amendment, 75%. And that can be either through the state legislatures or through constitutional conventions within those states. So again, another state-based institution that's a safeguard to protect state sovereignty. On top of that is, in many instances, states are called upon by the federal government to implement federal policies. And one of the procedural safeguards then is if states are called on to implement federal policies, they could reject the idea of actually carrying out these policies. Therefore, that gives the states power vis-a-vis the federal government. A couple of other things, congressional redistricting is done by state legislatures or is set in the law by the states themselves if it's a redistricting commission. But the states have control over congressional redistricting, so they can draw congressional districts for the House of Representatives that would reflect the interests of members of their state. And then finally, with the exception of a number of constitutional amendments, as we know, the 19th Amendment, the 15th Amendment, and so forth, the voter qualifications are something that's left up to the states as well. So there is no kind of constitutionally privileged position of states within, within the judicial system. Basically, what this theory of jurisprudence argues is that basically you punt and let the political system decide whether it's a federal or state power and who has control over things, right? Now, we're going to take a look at these two theories by taking a look at two cases here. I'm going to focus primarily on Garcia versus San Antonio Metropolitan Transit Authority, 1985. But it's important to go back to National League of Cities versus Usery in 1976. In this decision, the Supreme Court sided very heavily with the judicial safeguards theory, arguing that, in fact, there were traditional functions of the state government and non-traditional functions of the state government under the U.S. Constitution. And therefore, it was up to the Supreme Court to draw the boundaries of when the rights of states had been transgressed by the federal government. So it was a clear exposition of the idea that there are judicial safeguards and that should be what is included when we're examining whether or not the balance of power has been violated by the federal government between states and the federal government. Now, a mere several years later, less than a decade, what we saw was the Supreme Court came back and essentially reversed the decision of National League of Cities in Garcia versus San Antonio Metropolitan Transit Authority in 1985. And in this decision, which we'll look at, in depth here, the Supreme Court basically said, or at least the majority, it was a 5-4 decision. So the majority said it was too hard to delineate between what we consider to be traditional and non-traditional functions of state governments. Therefore, it wasn't really the job of the judiciary to do this. It would be too inherently political because this is often a contest of wills between the state and the federal government. We could only really leave it to the political safeguards theory. And therefore, let's just abdicate this, let it up to the structured government to determine all this kind of stuff. All right. So Garcia comes along in 85. And in essence, what we see, a very brief and short history of mass transit in the United States was that, for the most part, transportation systems, whether they be railways or buses, were private prior to the 1940s and 50s and really into the 1960s. But what we saw was with suburbanization and various other factors, that it did not prove to be economically feasible for private companies to be able to run transit systems. And what we saw was that states, vis-a-vis their local governments or various transportation authorities, stepped in and bought up these systems and used them as a government-run system of mass transit, right? So while it's been 70 or so years, it was not something that goes back to the core of the founding, that this was always a state and local interest. So what happens in this case is that in 1979, the Wage and Hour Administration of the U.S. Department of Labor basically said that the San Antonio Metropolitan Transit Authority was subject under the Fair Labor Standards Act to the minimum wage requirements and overtime provisions of the Fair Labor Standards Act. And essentially, San Antonio Metropolitan Transit Authority said, no, we're not. We're a local government agency. This has always been a traditional area that the local government's involved in. Therefore, you have no right to impose the Fair Labor Standards Act on us. And eventually this got to court, and it was up to the Supreme Court in 1985 to decide whether or not the Fair Labor Standards Act actually applied to the San Antonio Metropolitan Transit Authority. In other words, are you subject to minimum wage laws at the federal level and overtime provisions as well? So what we see is a very spirited discussion here, and that's kind of an understatement. It's a bitter 5-4 decision, overturns the National League of Cities case. And what we see is that the majority's decision here, written by Justice Blackmun, is a firm statement that procedural safeguards are really the only method of protecting state sovereignty. And then we see the dissent, most of the members of which had been part of the majority in the National League of Cities case, rallies around this idea of judicial safeguards. So let's see through this case how these two different things are argued and two different theories of how federalism can be protected. So in the first, the majority here, again, remember it's a 5-4 decision. Justice Blackmun says, they basically said National League of Cities, by a sharply divided vote, ruled that the Commerce Clause does not empower Congress to enforce the minimum wage and overtime provisions of the Fair Labor Standards Act against the states in areas that are of traditional governmental functions. Okay? It says that although National League of Cities supplied some examples of traditional government functions, it did not offer a general explanation of how a traditional function is to be distinguished from a non-traditional one. So there was no real test then, as far as the majority in Garcia is concerned, that helps judges differentiates this. So basically what they say is that our examination of the function since 1976, as it's been applied in other cases over the last 8 years, persuades us that the attempt to draw the boundaries of state regulatory immunity in terms of traditional governmental function is not only unworkable, but is inconsistent with established principles of federalism, and indeed with those very federalism principles on which National League of Cities purported to rest. That case, accordingly, is overruled. So we have this idea of stare decisis and precedent. And they're basically saying that National League of Cities was the outlier, and we are here to correct the wrongs that were impugned from the National League of Cities case, right? And then they go through and say, look, let's take a look at some of these things that have been going on here. It says, since that time, the courts have held that regulating ambulance services, licensing automobile drivers, operating a municipal port, performing solid waste disposal, and operating a highway authority are functions protected under NLC. At the same time, courts have held that issuance of industrial development bonds, regulation of infrastructure, natural gas sales, regulation of traffic on public roads, on and on and on again, are not entitled to immunity. And basically, they're like, how did they arrive at all this? Maybe there would be some kind of rule that we could look at, but from what they've seen of the operation of these decisions under the rules in National League of Cities, they basically say there's no organizing principle. This is just ad hoc, right? It's just whatever the courts seem to want to say it is. So their argument then is that, basically, if we're going to have a democratic society, we don't want an unelected judiciary making the decisions about what is state sovereignty and what is not. right? That is not up to us to decide. It's up to the political system to decide. Therefore, the idea of procedural um, procedural federalism is important. Right? Now, why? Why is it so difficult to understand that? Well, while most people kind of concentrate on this idea of enumerated powers that the government has, they take a look at the majority in this decision takes a look at the idea that the enumerated powers not only give power to the federal government, but they also cede powers from the state government to the central governments, right? So they give them up, right? And that creates this kind of very unclear dividing line between what's a traditional function and what's a non-traditional function. So there are three basic things that they point to where states cede powers to the federal government. And the first is, Article 1, Section 8 lays out, all the different things that Congress has the ability to be able to do. And then we also see that there's the Supremacy Clause, which basically says that, the federal law is the highest law of the land. And that way, through Article 1, Section 8 and the Supremacy Clause, state legislation can be displaced by federal rules and federal laws. Second thing, again, talking about the supremacy of federal courts, they are the final arbitrator of law in the United States, right? So that states have ceded that. It's not the state courts, it's the federal courts. And then finally, most of the Bill of Rights has been incorporated throughout the middle part of the 20th century onto the states vis-a-vis the 14th Amendment. Meaning that those rights that are considered to be fundamental in our ordered society have been applied not just to the federal government, but to the state governments as well. And as a consequence of that, states have ceded their powers to be able to regulate things like free speech and various other things that we see here. Blackman says the fact that the states remain sovereign as to all powers not vested in Congress or denied to them by the Constitution offers no guidance about where the frontier between state and federal power lies. It's just too complicated. How are we to know where the boundaries between what a state should do and what the federal government should do when the Constitution itself isn't particularly clear about any of this, right? So, basically, they make the argument that procedural safeguards is the only method that you can adequately determine what state roles is in American society. And from their perspective, SAMTA, or the San Antonio Metropolitan Transit Authority, is the same as any other business. As a private business, they're subject to the same laws of under the Fair Labor Standards Acts. And therefore, the idea of minimum wage and overtime should apply to them. And they're also saying that this is not really a recent activity or traditional activity. This is something that the states, as I mentioned, have basically gotten into since the middle of the 20th century. And as a consequence of that, could not be considered to be a traditional activity of the states. And then they kind of stick the knife in here a little bit. They're like, it's funny. It's funny that we didn't hear much from the states when the federal government was stepping into mass transit for the first time in the 1960s and giving money in very large amounts to mass transit systems around the country. We didn't hear any complaining from the states or the local governments at that point of time that this was a traditional function that the federal government should stay out of, right? So ultimately, they're subject to the same regulations as any other private party would be in the United States. If you've got a problem with that, then go to the Senate, go to the House, use the Electoral College, elect your president, and change the Fair Labor Standards Act and exempt, state and local governments from those provisions. Now, Justice Powell comes along with dissent that's also very withering. And this takes essentially the judicial safeguards approach. He says, because I believe this decision substantially alters the federal system embodied in the Constitution, I dissent. It gets even harsher here. Whatever effect the court's decision may have in weakening the application of stare decisis, all right, this is bad enough that they've overturned an existing decision. It's likely to be less important than what the court has done to the Constitution itself. A unique feature of the United States is the federal system of government guaranteed by the Constitution and implicit in the very name of our country. Despite some genuflecting in the court's opinion to the concept of federalism, today's decision effectively reduces the 10th Amendment to meaningless rhetoric when Congress acts pursuant to the Commerce Clause. Meaningless rhetoric, right? And they take issue with the idea that this is judicial activism. You remember Blackmun says, it's not the role of the courts to get involved in all this stuff because we're an elected body. Well, Powell says the exact opposite. He's like, well, it's funny that you mentioned that because you've just, as a judicial activist, Justice Blackmun, have just thrown out 200 years of jurisprudence on federalism by your decision saying that there are no judicial safeguards whatsoever for the federal system, right? So basically, he says there's a head scratcher here, right? And that people get angry in decisions when they go back to square one and quote things like Marbury versus Madison and McCulloch versus Maryland, and we see that in both of the dissents here. And basically, what we see Powell say here is, more troubling than the logical infirmities in the court's reasoning. The federal political officials invoking the Commerce Clause are the sole judges of the limits of their own power. So, in essence, they're making the argument of the judicial safeguards that the procedural safeguards people were basically saying there is no check whatsoever on the federal government. And that's okay because, the people in the federal government have, those institutions are affected by states. Powell says no. He says, the result's inconsistent with the fundamental principles of our constitutional system. At least since Marbury versus Madison, it's been the settled province of the federal judiciary to say what the law is. And if we don't have an intermediary body like the Supreme Court deciding what the law is, then there really is no reason for having a constitution. And here's where he makes a more complex argument then about why we need kind of judicial protection here. He goes through and talks about some of the Federalist Papers and says that the founders essentially believed that states and federal governments would counterpoise each other. In other words, balance them out, and that the state governments would be a counterbalance to the federal government, preserving people's rights. And it was important to have both of these polities functioning in their own sovereign ways. And it was believed by the founders, actually, that the loyalty of citizens would be focused more on their state governments than the federal government because they dealt with everyday concerns. But here's the problem. If we take away the right of those state governments to make determinations on their own, we're weakening the state government's ability to be able to check federal power. And that's not good for democracy. There's a little bit more to the argument there from Powell, but I'll leave it at that. And then Justice O'Connor has another dissent, which is very withering as well. She says, the court today surveys the battle scene of federalism and sounds a retreat. Like Justice Powell, I would prefer to hold the field and at the very least render a little aid to the wounded. I join Justice Powell's opinion. I also write separately to note my fundamental disagreement with the majority. The true essence of federalism is that the states as states have a legitimate interest which the national government is bound to respect even though its laws are supreme. Okay? So basically says that, the commerce power is important, but it's limited. And the majority in this decision basically just ran completely roughshod over the 10th Amendment, just at the expense of the 10th Amendment, in essence saying that the Commerce Clause was far more important. It says basically, because virtually every state activity, like virtually every activity of a private individual arguably affects interstate commerce, Congress can now supplant the states from the significant sphere of activities envisioned for them by the framers. This is a problem, right? And in essence, she argues that there needs to be a test, right? We wouldn't just leave it up to our political system to decide any other conflict within government. The proper resolution, I suggest, lies in weighing state autonomy as a factor in the balance when interpreting the means by which Congress can exercise its authority on the states. It is insufficient in assessing the validity of congressional regulation of a state pursuant to the Commerce power to ask only whether the same regulation will be valid if enforced against a private party. That reason, embodied in the majority opinion, is inconsistent with the spirit of our Constitution. It remains relevant that a state is being regulated. Right? As far as the Constitution is concerned, a state should not be equated with any private litigant. Instead, the autonomy of the state is an essential component of federalism. And O'Connor says, yeah, it has been difficult to discern what's a traditional versus non-traditional realm of state government power. But we can't just give up. This is too important. If we do give up, we're essentially gutting the idea of the independence of states and leaving them at the behest of the federal government. So there have been lots of other decisions that kind of fill in this blank since 1985, as you might imagine. However, these two basic theories of procedural federalism versus judicial federalism are essentially the two conflicting things that we see most often harbor among our justices in the Supreme Court and scholars of federalism. So they're very important to take this and then build upon it by looking at other cases as we discuss the law and federalism and the Supreme Court in the United States.